We will discuss the following topic. Power of Arbitral Tribunal to order interim measures, Article 17, Recourse against award, Article 34, Recognition and enforcement of awards. Contracts for the international sale of goods. Termination of proceedings, Article 32. The arbitral proceedings are terminated by the final award or by an order of the Arbitral Tribunal. The arbitral proceedings can be terminated by the order of Arbitral Tribunal if A. Claimant withdraws his claim. B. Parties mutually agree to terminate proceedings. C. Arbitration has become unnecessary. Power of Arbitral Tribunal to order interim measures, Article 17. The Arbitral Tribunal may, at the request of a party, order any party to take such interim measure of protection as the Arbitral Tribunal may consider necessary in respect of the subject matter in dispute. Making of award. Article 28. Decision of the Tribunal shall be based upon the rules of law chosen by parties. Article 28. If rules not chosen by parties, then the Tribunal shall apply law it sees fit. Article 29. Decision shall be reached by majority of the arbitrators. Settlement. Article 30. If, during arbitral proceedings, the parties settle the dispute, the Arbitral Tribunal shall terminate the proceedings. Form and contents of award, Article 31. The award shall be made in writing and shall be signed by the arbitrator or arbitrators. In arbitral proceedings with more than one arbitrator, the signatures of the majority of the members of the Arbitral Tribunal shall suffice. Article 33. Additional award may also be requested by the party within 30 days of the receipt of the award which has not been mentioned in the award. Recourse against award, Article 34. An arbitral award may be set aside by the court specified in Article 6 only if the party making the application can prove that 1. A party to the arbitration agreement was under some incapacity, or the said agreement is not valid under the law to which the parties have subjected it. 2. The party making the application was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings or was otherwise unable to present his case, or 3. The award deals with a dispute not expected by or not falling within the terms of the submission to arbitration. 4. The composition of the Arbitral Tribunal was incorrect. 5. The subject matter of the dispute is not capable of settlement by arbitration under the law of this state. 6. The award is in conflict with the public policy of this state. Recognition and enforcement of awards. An arbitral award, irrespective of the country in which it was made, shall be recognized as binding. Article 35. In order to enforce the award, the party will have to make application to the court. Article 36. The court may refuse enforcement of award if A. Party to the arbitration agreement referred to in Article 7 was under some incapacity, or the said agreement is not valid under the law to which the parties have subjected it, or, failing any indication thereon, under the law of the country where the award was made. The party against whom the award is invoked was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings or was otherwise unable to present his case. C. The award deals with a dispute not contemplated by or not falling within the terms of the submission to arbitration. It contains decisions on matters beyond the scope of the submission to arbitration, provided that, if the decisions on matters submitted to arbitration can be separated from those not so submitted, that part of the award which contains decisions on matters submitted to arbitration may be recognized and enforced. D. The composition of the Arbitral Tribunal or the arbitral procedure was not in accordance with the agreement of the parties or, failing such agreement, was not in accordance with the law of the country where the arbitration took place. E. The award has not yet become binding on the parties or has been set aside or suspended by a court of the country in which, or under the law of which, that award was made. If the court finds that 1. The subject matter of the dispute is not capable of settlement by arbitration under the law of this state, or 2. The recognition or enforcement of the award would be contrary to the public policy of this state. Contracts for the international sale of goods. Application of UN Convention on the Contracts for the International Sale of Goods, UNCISG. This convention applies to contracts of sale of goods between parties whose places of business are in different states. Article 1. A. When the states are contracting states, or B. When the rules of private international law lead to the application of the law of a contracting state. This convention does not apply to the liability of the seller for death or personal injury caused by the goods to any person. Article 5, Article 6. Under this article, parties have the option to exclude the application of this convention. Convention is based upon the basic principle that it is international, uniform and based on good faith. According to Article 9, the parties are bound by the customs or the practices of trade. Thanks for WTC Hing.